Hello everyone. I want you to understand the importance of the punishment and suitable punishment for crimes. Understanding these things will help you to understand and decide for yourself if the punishment fits the crime. Questions like, what is a violent crime? What is a non-violent crime? And who has the power and the final say to execute these judgments? Introduction. My name is Paula Brown and my major at Columbia is criminal justice. I am also the executive assistant at a law firm that handles a variety of cases, but most specifically and most often, we practice criminal defense. Working in this particular environment, I have come to witness that sometimes the punishments that people receive are not suitable for the crimes that they have committed. Definition of a nonviolent crime. A nonviolent crime are crimes that do not involve the use of force or injury to another person. Things like theft, larceny, embezzlement, receiving stolen property, false declaration to a pawnbroker, drugs and alcohol-related crimes, prostitution, bribery, fraud, typical white-collar crimes. These crimes are considered nonviolent. The definition of a violent crime. A violent crime is a crime of a violence in which the offender or the perpetrator uses or threatens to use force upon a victim. The use of a weapon can raise the seriousness of these crimes. This entails crimes that are violent in that they are murder, rape, assault and battery, kidnapping, false imprisonment, as well as crimes that involve violence is the means to an end. Some crimes are considered violent if the victim is not injured, so you don't have to be necessarily injured for it to be considered a violent crime. A violent crime like assault and battery with the intent to do bodily harm carries a range of punishment for up to 10 years in prison. Shooting with intent to kill carries a range of punishment up to life. Nonviolent crimes like possession of a CDS, which is a controlled dangerous substance, carries a range of punishments as up to 5 years in prison and fines not exceeded $5,000 for the first offense. For your second offense, however, it carries a prison time up to 10 years and fines not exceeding $10,000. These punishments can be altered and determined on certain circumstances. For example, the quantity of drugs you had, the distance that you were within a school, if you were near a school while you had the drugs on your body, having that in the presence of a minor child. These things can contribute to you not being able to get a lesser sentence because you've committed something and you've done it in an area where you're near a school where children can be harmed or in the presence of a minor. Petty larceny carries a punishment of fines no less than $10 up to $500 or imprisonment or even both. So you can go to jail and pay a fine if you were to steal from a retailer or a person. What is a suspended sentence? In a legal term, when a judge puts a defendant going to prison after they've been found guilty, that puts the defendant on a probationary period, either supervised or unsupervised. If the defendant does not break the law during this period and completes the conditions of the probation, the judge will normally dismiss the sentence. What is an application to revoke? This process in the criminal justice system involves the prosecution, the DA or the ADA, and the judge to overturn a suspended sentence of a defendant and send that defendant to prison. A plea agreement. A plea agreement is in a criminal case is between the prosecutor, again, the DA and the ADA, and the defendant, where the defendant agrees to plead guilty to a particular crime in return for leniency. This simply means that the defendant will plead guilty to a less serious charge in return for a more lenient sentence instead of taking the case to trial. In some cases, as part of a plea agreement, the defendant may agree to enter like a veterans program, a drug court, RID, or community sentencing program. These programs are there that offenders can get a second chance at life at making a better decision in the future. What is paper time? Paper time is the time used to describe someone who is on probation for a suspended or deferred sentence. It's like prison time, but they're serving it out of custody. So it's considered time to do, but not locked up. Some people have to do up to 15 to 20 years of paper time. Who has the power to determine the punishment? The DA, the ADA, and the judges have the power. They determine what punishment, how long it will be, and what type of punishment it will be. Keeping in mind, however, that the range of punishment for the crime has to fit the crime, like we've discussed before. The law defines what the range of punishment is, and the judge, the ADAs, they must follow that to the letter of the law. Unfortunately, though, they can, however, max out that sentence, depends on what the crime is. Should they have the final say? I don't think so. By the law, they do have the final say. They were given that power. As long as they have to make the final decision, they will have the final say. That should not be the case, because they are supposed to render an unbiased judgment, and they cannot always do so, therefore letting their feelings and stuff make a decision for them. Sometimes their decisions are unfair based on race and gender. So therefore a judge should not have the final say, because they are human like we are. A trial by jury. A jury trial is a lawful proceeding in which 12 citizens are sworn in to render an impartial decision or findings of facts based on evidence presented to them by the prosecution and the defendant's attorney. Rehabilitation over incarceration. Rehabilitation is giving the person the opportunity to right their wrongs. They go through therapy and other programs that help them recover from addictions and other issues that may have caused them to commit this crime in the first place. Incarceration places people in prison or in jail to serve time for crimes they have committed. In many cases, for nonviolent crimes, people should be able to get a second chance via rehabilitation programs instead of being incarcerated. Incarceration sometimes makes it harder for that person to have a normal life after they've been in prison. Jobs are harder to find, and life can be very challenging after prison, forcing them back to a life that they were in prison for. It's called a revolving door of the prison system. Our firm recently had a case where a young man was sentenced up to 20 years by a judge for a revocation. His previous punishment for that crime, which was driving a car while the passenger discharged a firearm, no one was injured, and he had a deferred sentence, a 5-year deferred sentence, meaning he agreed to stay out of trouble for 5 years and he would not have served any prison time. He would be on paper time. Well, he got in trouble for a nonviolent crime and received a revocation from the previous incident. The judge then sentenced him to 27 years, the maximum punishment for the crime that he committed before. He's 20 years old. He'll be 47 years old when he gets out of prison. Instances like these is what makes me feel that some punishments are too harsh for crimes. And that makes me want to pursue a career in criminal justice as a criminal defense attorney. When he is released from prison, he won't be able to find a job, and there will be ions of technology ahead of him, and he will not be familiar with. He'll probably be forced again to turn back to a life of prison and a life of crime in order to survive. We're back to the revolving doors. Making you understand again why I believe that the range of punishment for a crime sometimes are too harsh for the crimes that are committed.
Very good.